breaking down the bombshell in FSU's motion to dismiss.
The ACC lawsuit is always in the news, so we're back on the big mountain to keep you updated.
Hey, it's great to have you here on the mountain. If you're new to the channel, I am JY, and this is my good friend Steve. Steve, we're going to do another episode on this motion to dismiss. We just did one a few days ago. We had it come out on Monday. This is going to come out on Thursday. We went over the items that FSU put in this motion to dismiss. Pretty high level. We talked about our original viewpoints on that. And then we've had a few commenters, and I've seen a lot of headlines on one of the items that we really didn't take a lot of, we didn't talk too much about. I want to break it down here further. I've been, seeing some headlines and commenters saying this is the bombshell of this whole thing. And so let's talk about this bombshell.
Okay.
Just as a reminder, we're not lawyers. We're laymen, although I did converse with the Big Mountain's in-house counsel on some of this, so I'll get to that in a minute.
All right.
Also, we are not ACC or FSU fans at all. We are Big Ten and Mountain West fans. We just enjoy covering this. We got on the Pac-12 and covered that. Now we're covering the ACC FSU issues because we've done a lot on realignment and expansion, and this is going to play into some of that eventually. But yeah, so anything you want to add to that?
I was just saying for, our Big Ten fans, our Mountain West fans, they're like, why the heck are these guys talking about FSU and ACC and the PAC and all that? I mean, these are things that are going to be affecting the Big Ten moving forward. Mm-hmm. If Florida State leaves the ACC, one of their most desired landing spots sounds like it'd be the Big Ten. Yep. So that could have huge ramifications for the Big Ten, and obviously everything going on with the PAC and the Pac-2 now,
yes,
could have huge ramifications for the Mountain West. So
yep.
we're going to keep doing it. It's a lot of fun to really break down, get into the details, and just have a discussion.
Yeah. So let's get into this. I did review the brief that was put in alongside this motion. Didn't have a chance to review that prior to our first episode. Just really went with what was in the motion. So some of what we're going to be talking about is actually coming out of that brief. That brief was much more detailed than the motion was. And I specifically want to look at the motion to dismiss that states the amended complaint fails to plead the FSU board either signed the grant of rights or approved them upon the proper notice and a vote. Basically saying the Board of Trustees did not approve the grant of rights. So let's break this down a little bit further. The brief gives further detail saying that the board is the only entity that has statutory authority to contract on behalf of Florida State University. The grant of rights named FSU as a party and then was signed by the then president at the time. They go on to say that the ACC makes conclusory, that's a hard one, conclusory and vague allegations that the FSU president was authorized to agree to and to execute the grant of rights. In truth, they state the FSU board never cast a vote to approve the grant of rights. So what does that mean? Basically, they're saying this contract is void. It's no good because the board did not approve this grant of rights. The board didn't sign, the board president or whomever did not sign this grant of rights. Now, I will say we mentioned this originally in the ACC filing, where the ACC was very clear that their signature pages were both saying that the person signing this was not only signing the grant of rights, but also signing that they had authority to sign this grant of rights. So that was on there. We talked about that. It's in the ACC filing. I've seen the paperwork. It's there. So yes, it was signed by the president. So while all of this may be true in terms of what the FSU is claiming and saying, it frankly, I think, holds little weight, if any. And again, I talked to our in-house counsel for TBM, and yes, he is a lawyer. If people are going, well, who's this guy off the street? No, legit lawyer. And he brought up two things. And to me, this is why the signature being the president is still a good signature for this contract. Number one, the president has apparent authority. This means it's reasonable to assume that they had the authority to sign this document. Not only was it apparent authority, but it actually said in the document that you're signing this saying that you do have the authority. So it maybe is even one step further than apparent authority. It is them stating that they have it. And when you get a document, and I'm going to give an example here in a minute of how this maybe plays out in a different situation, but when you get a document that's signed by the president of a university, clearly there's some sort of an apparent authority that president has the authority to sign that document. That's what we're talking about.
He's the chief executive
Absolutely.
Of the university.
Chief executive. Well said. The next thing is any steps toward performance of this contract, this grant of rights, ratifies the agreement. What are we talking, Steve? 10 years? 10 plus years from the original grant of rights? Some amendments and things all along the way? Clearly, there's been plenty of performance over this time where, the grant of rights has gone to ESPN, and there's that ESPN agreement. They've broadcast it, and FSU has gotten plenty of dollars for the grant of rights. I know what FSU fans are going to say. They're going to say, we should have gotten way more than that. Okay, that's a different discussion for a different time. I'm talking about the validity of the contract, aka grant of rights, and that the performance over this time has ratified that agreement. So for those two reasons, this does not hold much water. Now, I said I want to get into an example, so let me do that, kind of make it maybe a little easier to understand, although I think it is fairly clear. So say a business enters into a contract with a university, a public university, any sort of governmental entity, a school district, university, whatever the case may be. But they enter into this contract. And the contract is then signed by the president or superintendent or the chief executive, as you said, signed by the chief executive. That contract then is sent back to this contractor, the vendor, and performance is done over several years, whether it's a service or whatever the case may be. We have performance happening. Everybody's happy with it. Everything goes good. Say 5 years later, a new board is elected. University Board of Trustees, school board, whatever the case may be. And they want to challenge this contract for whatever reason. The reason, frankly, is irrelevant because the board never approved this contract. The challenge really doesn't hold any water because at the time, the chief executive had apparent authority to do something like that and to sign that contract, and the performance has been going on for a while, thus it's ratified. I will say, as a contractor, for those of you that own a business or know somebody that owns a business, I don't know any contractor that's going to research if the president has the right or the chief executive has the right to sign a contract. It's applied that they do. So the issue here, I think, honestly, lies within the internal workings of FSU. And if it didn't get to the board and the president just signed it and it didn't go to the board level, that's an issue within FSU back at that time. Maybe kind of the finger should be pointing at the president, if that's the case, but that's the claims that FSU is making right now. But, as I said, I think this fails. I don't think there's any bombshell in this whatsoever. Frankly, the facts just don't support it at all. It is a contract. It was signed for the reasons that I said. And this is not a reason to dismiss this case at all. What are you thinking, Steve?
Yeah, so I think overall, we've talked about this in other episodes, I think the Florida State lawyers have made some great arguments in their initial lawsuit and then in their amended filing. Mm-hmm. I think they have multiple avenues, multiple paths to, basically, getting out of the grant of rights or minimizing the amount of money that they have to pay to get out when they leave, either reducing the severe withdrawal penalty or, they have multiple great paths to getting what they want here. I've always been a little puzzled. A lot of the Florida State fans have, kind of gravitated toward this particular argument, right, and it never made a lot of sense to me. So this isn't one of those that I've ever considered a real strong argument for a lot of the reasons you bring up. Mm-hmm. First of all, so in my day job, I am constantly reviewing agreements, documents between universities, institutions of higher learning, and government entities, state, federal entities, and other in agreements between institutions. Yeah. Because a lot of universities have agreements with other universities, and always, it is the president of the university. Some schools might call it a chancellor. Whoever is the chief executive officer of that university is always the person signing these. That's completely normal. If if Florida State were to have some kind of internal process like that, then that's on them. That's between their board and their president, or whatever. So I've never thought this argument really held a lot of weight. And then you talked about performance. We had gone through that heavily with the PAC.
Yeah.
Talking about how basically the terms of an agreement, so especially if they're vague or ambiguous when they're written. So it's not always how things are written that are important. It's how they're performed. Okay. And once you start, you can say, hey, we didn't really mean this, or we didn't really mean that in agreement. But if you're performing that way, you're doing this and you're accepting payment, and in this case, multiple times over years, you're performing that contract. So your performance is going to carry more weight than the actual words on the agreement or whatever. So I don't see it. I just don't see this as being a big issue. Now, what I will say for those, I know there's a lot of Florida State fans. They are eager to get out of the ACC.
Yeah.
They are eager to get to the Big Ten or the SEC, whatever. They want to get out of that conference. Something I mentioned many times when we talked about the PAC is the signal and the noise. Yeah. Okay, there's a lot of noise out there. I've been on the War Chant message boards, whatever. They've got people just throwing out wild stuff, wild theories, and it gets exciting. Like you get wrapped up in it. It's a rabbit hole. Ooh, this and ooh, that. But what's really important is the signal. Sometimes you have to just take away that fluff, that extra noise, and focus on the signal. Focus on what the really important arguments are that the Florida State lawyers are making. What did they do in their amended filing? What has the best chance of succeeding? Not necessarily what's the most fun argument, but what has the best chance of succeeding? And we're going to see that when we already saw the amended filings, but there's other due dates that are going to be coming. There's also going to be potentially discovery requests.
Right.
So those are going to be telling of what evidence they're looking for in discovery, who they want to interview on the record, what documents they're looking for. So I would say pay attention to those paths, those strong paths, if you're a Florida State fan, of what the FSU attorneys are really working on, and maybe try and not pay attention to the fluff a little bit.
Although it's fun.
It is fun.
Well, one more thing on this, and then I want to go over the other four real quick, because again, I gleaned a little bit more out of the brief that I want to talk about. And I do want to talk about the stay. There was a whole other section regarding the stay. And there's one piece here that, I'll give probably the most weight to, and that'll be at the end. The only other thing I want to say about this, this specific motion to dismiss is this whole Florida statute. The Florida statute says X, Y, and Z. Okay, again, I get back to the Florida statute says that for Florida State University and the president, they should be following that. If they're not following that, don't blame the ACC for that. You should be blaming your institution for that. So I just wanted to throw that out there because I know that's been brought up a couple times. It was in their filing. Florida statute X, Y, and Z. Okay, great. Then follow your statute, Florida State. So the other ones. Let's go back to the very beginning. The first one was ACC filed the complaint prior to any actual controversy. We talked about that briefly. In reading the briefing, it was a word salad to me in what they had in there. It was just kind of all over the freaking place. And to me, it's just a misinterpretation of the actions brought by the ACC. I mean, they basically are just saying, hey, they took action before us just so they could get a leg up on it. And I would say go back and watch our episode on the ACC filing, because what they talk about there is disclosure of trade secrets that FSU has repeatedly given out, these trade secrets and these fiduciary responsibility types of things, and they're throwing them out there. They've been warned about it. So, it's not so much they did this. I mean, yes, they did it to counteract FSU. But the actual motions and what they are asking for aren't specific to the grant of rights. It's other things that the ACC is talking about here. So, again, it was a word salad. We said that one, the timing thing, we see that failing. I continue to agree. There's not much there with that one.
And a big part of the problem with that is that, yes, they filed it first, but they filed it after the Florida State Board of Trustees had a public meeting, publicly available meeting, where they were throwing all this out there, and they voted to give authority to their solicitor to go ahead with the lawsuit. So
right. I'm going to get back to that in some way when we get to the stay portion of this. So right now I'm just talking about the dismissal. Okay. So I don't think it holds water for dismissal at all, but I do want to get back to that with the stay portion, which is the other half that they're asking for. So the second reason to dismiss did not obtain the 2/3 vote from the members. We talked a little bit afterwards. It's a standing issue. Did the ACC have standing in order to bring this suit? I think there could be some merit here. We talked about that last time, so I'll say this one's I'm a little unsure of the outcome here. I still don't think it's enough for a dismissal. But, I give that one a little bit of credence.
This is the 2/3 vote.
The 2/3 vote by the ACC members in order to, have some litigation. The item number 3, ACC failed to sue FSU in the only jurisdiction where they waived sovereign immunity, which would be the state of Florida. Now, I said that a little bit differently than we said it before, but it's always around this sovereign immunity piece. In the Florida State Statute 1001.72, FSU claims the phrase all courts, which we talked about originally, but all courts refers only to courts in Florida. So this statute's only talking about they're waiving their sovereign immunity in the state of Florida. We'll see. I don't know. I have no idea how the judge is going to view that. That's what they put into this brief. Again, a little unsure about the outcome there. And this one kind of falls into the stay as well. So stay tuned when we get to the stay. We just talked about the bombshell that we don't think it's a dud. Never blew up, won't blow up. The last one, ACC claims are not supported by North Carolina law. Basically, they state 3 of the ACC allegations should be dismissed because FSU owes no duties to the ACC beyond the Constitution and their bylaws, not the grant of rights. Again, I think this is pretty unlikely to succeed. So it leads me back to our original kind of the 2/3 voter member and the sovereign immunity and maybe something there. Again, I just don't think there's enough for a dismissal of the case. So anything there before I go into the stay, Steve?
I would say, first of all, motion to dismiss, I think is just they're just putting it in there. It's a Hail Mary, maybe they get lucky kind of thing. I don't see anything in there that would merit a dismissal this early in the game.
Yes.
And I know you're going to get to the stay, and I'll just say, I think a lot of the arguments they make definitely have a lot more credence towards staying this case in North Carolina and letting the state of Florida play out.
I agree. So let's get to the stay. And this was a piece we brought up before, and they actually answer a question of ours. Because, so what they say here is ACC's choice of forum, a.k.a. North Carolina, should be disregarded in favor of FSU board's forum, a.k.a. the state of Florida. And we had said before that typically when this comes up and you have cases in either case, it kind of reverts to whoever filed first. Mm-hmm. There's a stay on the second case, and you kind of first hear that first case, and then there's a stay, meaning the Florida state case would be stayed. However, they actually address this in this brief, and they say that, again, they bring up this fact that priority is usually given to the party that files the action first. However, this can be disregarded when the plaintiff has notice of imminent or pending litigation and is used as a means of procedural fencing in order to ensure a more favorable venue and deny the true plaintiff the forum of choice. They go on to state where North Carolina courts have adopted this and applied this exception in the past. So I did find that interesting. The last time we reported on this was kind of that beginning piece. It's usually given to the party that files first. They talk about exceptions that can be given to this, so they are kind of picking at that. And I would say of everything I read in this case, if this exception is granted by the judge for the reasons they're giving, I think this holds the most weight in order for them to stay this case because of these exceptions in their wording, this procedural fencing. And then it moves to Florida. So to me, it's not as pretty, it's not as big of a bombshell, but this is the one that I honestly think at this point could actually get this case moved to Florida first. What do you think?
Yeah, well, I agree with you on that item. And again, we talk about the signal and the noise. This might not be the pretty argument, but it might be the one that gets them what they want. Now, I will say, I think going back to some of those other points, I think the 2/3. So I think the judge in North Carolina has a couple outs in this, because the worst thing that you want is basically to have kind of dueling courts, one in North Carolina and one in the state of Florida. So I think this gives a couple of these items give the judge a couple outs. One, he could issue a stay in order to determine, okay, did they need a 2/3 majority? Did they get that 2/3 majority of the ACC board to get that approval to move forward? And that's a simple, hey, we're going to stay this case until. And then as far as the issue of, and I agree with everything you said on that last part, but I'll talk about the Florida, the sovereign immunity. That's another out, because it would be very easy for the judge in North Carolina to say, hey, we're going to stay this trial, we're going to stay this lawsuit here, because that issue needs to be worked out in Florida. Yep. It's Florida State is a public entity. Yep. This is Florida law, and who am I in North Carolina to rule on that? And so that issue of sovereign immunity needs to be worked out in the state of Florida before we can even determine or do anything here in North Carolina. So I really think the judge has a few outs there. Do I think that there's the motion to dismiss? To me, if any of our FSU fans are out there, hoping that happens, I think it's fool's gold. Yeah. I would say less than 1% chance, but I do think there's a couple avenues here that really could lend themselves to getting a stay and having this move to the state of Florida. Which, if that were to happen, that's a huge victory for Florida State. Yes. Huge victory for Florida State.
Yeah, agree. And that's my takeaway of all this, was that the most, if anything comes of this filing of a motion to dismiss or stay, my takeaway is a potential stay. I'm not going to give it a percentage. I'm not a lawyer. I have no idea. But where there could be a bit of a fire, if you will, and the out, like you call it, could be this stay because of a combination of just, the exception to filing first, the sovereign immunity piece, the action pieces. You kind of combine that all into one thing, and he stays it for several reasons. I completely agree with you, Steve.
And I just want to add, if you put yourself in this judge's position, okay? There's an assumption there, because it's in North Carolina, that it's automatically the judge is going to be favorable to keeping the ACC together. Yeah. He's going to be favorable to the interests of UNC, North Carolina State. Well, we just had the chairman of the Board of Trustees for North Carolina for their university system come out and basically just say, hey, there's people have to be realistic in today's atmosphere, that there's a very good realistic possibility that both of those schools are going to be leaving the ACC and possibly going in different directions, maybe together. So I don't think people should assume that. And again, if you're in that judge's position, do you want to be in a position where you make rulings, okay, on this case, and then after you make your rulings, it goes back to the state of Florida, right, and then they go ahead and rule that Florida State is completely immune, right, due to sovereign immunity? Right. Where does that put your status, the status of your case and your ruling? That's just kind of quicksand for that judge. So I'm going to make the prediction that, using at least one of those things that we brought up, okay, possibly more, that the judge of North Carolina is going to issue a stay, and that this case is going to move to the state of Florida first.
Okay, well, there you have it. So a bombshell, but maybe different than what people thought they were going to get when they clicked on this. So, hey, we try to stay on top of this stuff. We will bring you news that it comes out. Again, we're not a breaking news channel, but we are a deep dive channel, if you will. Try to look at it from some different angles. And if you want a third party that doesn't have a horse in the race, maybe we're your guys. So make sure you give us a like. Make sure you give us a subscribe. And with that, we'll see you guys next time on the Big Mountain.
The bombshell looks like it might be a dud.